I'm probably the last thing standing between y'all and the beginning of your spring break, so I'm not gonna take too much time. I was walking yesterday on campus after the softball game, and I came upon something. Everybody see that? Who can tell me what this is? I don't want to know the name of it. What is this an example of? A safety hazard is good. Caleb? Negligence. Very good. Remember, negligence requires the existence of a duty of care, the breach of that duty, causation, and damages. So which element would this go to? Back up some more. Not quite causation. The breach of duty, right? Because why? The duty is to guard against reasonable sources of danger or injury, and they left that off in a place where people walk and kids play. And that's certainly, is it foreseeable to you that if they forgot to put that cap back on that somebody could get hurt? Yeah. Maybe not during the day, but especially at night if there's kids playing around. Good. One of the curses, I think, of teaching this class is that I think about negligence all the time. And when I see it, I feel compelled to photograph it and bring it to your attention. Also, I didn't take a picture of it, but I wanted to. There was a stop sign on the street near where I live where a tree branch has grown to where you can't see the stop sign. And I was like, I think that would be negligence on the part of the city or whoever's in charge of that. And then I also, I don't know where this picture is, but I joke in here. One of my examples I always use is if I had a wreck or driving down University Drive, or frequently my scenario is I'm driving down University Drive, and Tuesday after class, somebody got pulled over right in front of me. So I was trying to get a picture of that too, to show that you do have to follow the law on University Drive. All right, so we're going to pick up then with part 2 of our contract law lecture. We ended part 1 in the middle of discussing the elements of a valid enforceable contract. Those 4 elements were agreement, which we broke down into offer and acceptance. We talked about that most of the class on Tuesday. Second element would be consideration, which we'll get into today. Third element is capacity, which we'll also get into today. And the fourth element is legality. So I'm going to start at consideration. I'm still in the outline for part 1. Consideration is the value of the promise or the obligation that each party to a contract gives, right? Without consideration on both sides, we don't have a valid enforceable contract. I told you Tuesday that if I promise to give Ms. Rivera $20 after class and I don't do it, she doesn't have an enforceable contract because there's no consideration given on her part. Consideration I'm giving to her is $20, but she's not giving up anything in return. Consideration distinguishes a contractual relationship from a gift. Okay? Consideration has to be of legally sufficient value. That means that each party has to give up something of value or refrain from doing something that they have a right to do. Courts generally do not get into the sufficiency of consideration. All right? Courts generally do not get into whether or not you made a bad deal, or the value, the consideration given from each side was not equal. The courts presume that you know that you have the freedom to contract, you know what things are worth to you in that moment under those circumstances, and you're free to determine those. They won't help you out on the back end if you made a bad deal. So as long as you've given up something of value, each side has given up something of value, the consideration element is going to be met. When I talk about consideration having to be something that someone is not already legally obligated to do, let me give you an example of that. If in my very basic example, I ask Caleb if he will drive me to my office after class in exchange for $20. All right, the consideration on his part is he's giving me a ride. On my part, it's that I'm paying him $20. Did he have any responsibility before we made that agreement to take me to my office? He did not. Did I have any responsibility or legal obligation to pay him $20 before we made that agreement? No. So we're both doing something we weren't previously legally obligated to do. If, on the other hand, let's say use teaching at CSU for an example. I sign a contract every year for a 1-year contract to teach X number of classes in exchange for X number of dollars. If in the middle of the year, say before spring semester started, I went to Dr. Finley, who is my boss, and said, I'm not teaching this spring unless you give me a $50,000 raise. And he says, okay. The dean finds out about it, and the dean says, absolutely not. I sue CSU for breach of contract. Did Dr. Finley and I have an agreement? Yeah. But is there consideration given on both sides? Consideration from CSU would be $50,000. My consideration would be, I would say my consideration is I'm going to teach spring semester. CSU would say that doesn't count as consideration because he's already legally obligated to do that. He's already under contract to do that. He's not giving up. He's not doing something that he wasn't already legally obligated to do. All right. So consideration has to be of value, although the courts are not going to get into comparative value. It just has to be something of value that you are not legally already obligated to do. Let's look now at some situations where consideration is lacking. We just looked at one, which is where I had a pre-existing legal duty. All right, so whenever somebody has a pre-existing legal duty, that pre-existing duty cannot serve as consideration for a new contract. Same thing goes for past consideration. I can't use something I've already done in the past as consideration for a future contract. Let's say we get to the end of the semester and I go see Dr. Finley and tell him that I would like to have $50,000 more because I did a really good job this semester. And he says, okay. Dean finds out about it, says no, I take him to court. The problem for me in that court case is that I didn't give any present consideration. My consideration was past. I've already done it. So past consideration cannot serve as consideration for a present contract. There's also a situation when consideration is lacking, but the court might, we're going to talk about two situations where consideration is lacking, but the court might enforce one of the parties to go ahead and discharge their promise anyway. All right, so these next two examples we're going to talk about for the next 5 minutes. There's no contract, but the court might enforce the promise anyway. They're not enforcing the promise under contract, under the theory of breach of contract. There are other legal names for it. One is called promissory estoppel. All right, promissory estoppel allows one person to recover the promise from another when there's no consideration on the part of the plaintiff. That sounds kind of abstract and confusing, so let's take an example. Let's say that I'm on the board of the Boys and Girls Club, and I have been for 25 years. And let's say that I am a well-known philanthropist. I've given a lot of money to a bunch of different causes. I've given a lot of money to the Boys and Girls Club in the past. And at our board meeting in last April, I said I would give them $2 million for them to build a new facility. They go out and buy an $800,000 piece of land. They engage an architectural firm to draw up the plans. They engage a contractor to build. They start building. And in the middle of the build, I say, just kidding. I've decided I'm not giving you that money. They sue me. They can't sue me for breach of contract because we don't have a contract. And why don't we have a contract? What's lacking? What element is lacking? It's not agreement, because I said I'll give you $2 million and they said, great, we agree. The problem is consideration. They didn't do anything on their part. They didn't give up anything of value in exchange for my promise to pay. So they can't use contract law theory to enforce my promise. But they could use promissory estoppel. Promissory estoppel works like this. If a person makes a clear and definite promise, and the person knows that the other person is going to rely on their promise, and that reliance is reasonable, and if that person actually relies on the promise to their detriment, then the court might use promissory estoppel to enforce the promise. Remember, we're not enforcing a contract because we don't have one. They're going to enforce that promise. So in my example with the Boys and Girls Club, did I make a clear and definite promise to them when I said I'll give you $2 million so you can build your new facility? Sure. Should I have known that they were going to rely on that promise? Yeah, I've been on the board for 20 years. I've given them money before. Very reasonable that they would think that I was going to give them the money. Did they rely on my promise to their detriment? Yes, because they went out and bought an $800,000 piece of property. They've spent money retaining a contractor and plans. They clearly have relied on it to their detriment because now they're in the middle of a construction project that's worth $2 million and I'm pulling out my promise to pay for it. In a situation like that, the court might enforce the promise that I made to them under the doctrine of promissory estoppel. Doesn't happen very often, but it could. Let's go back and change the facts on that a little bit. Let's say that I promised them, let's say that I'm not on the board of the Boys and Girls Club. I have never given them money before. I am a very unsuccessful businessman. I'm actually a hobo, and I live under the 185 bridge. And I'll walk into the Boys and Girls Club one day and tell them that I'm going to pay them $2 million so they can build a new facility. I don't do it. They sue me. They can't sue me for breach of contract, right? Because we don't have one. But if they try to use promissory estoppel, did I make a clear and definite promise? I did. I told them I'd give them $2 million. Did I expect that they were going to rely on it? Iffy. I'm a homeless hobo. I don't think anybody's going to rely on any promise that I make to give them money. Was it reasonable for them to expect that I was going to give them the money? No, not under those circumstances. So promissory estoppel would fail for them in this case. What about if Lindsay, what would you say if I'm on the board of directors, I've given them a lot of money, I have a lot of money, I promised them $2 million, and then the next day I write an email to the CEO and say, I can't do it. I'm not going to give you the money. Can they sue me under the doctrine of promissory estoppel, do you think? What's the problem with their case? There was a clear and definite promise. Was it reasonable for them to expect that I would do it? Yep. Did they actually rely on it to their detriment? Not if it's the next day and they haven't done anything. Right? That's where I'm going with that. It's really to compensate someone who has been who has relied on to their detriment on the promise, right? I'm making up for what I caused them to incur. If they didn't incur any money or expense or anything like that, then there's nothing for the court to really make me pay them for. So the key to that is reliance, whether the reliance is reasonable and whether or not it was they relied on it to their detriment. All right, the second situation where a court might force someone to pay when there is no contract is a quasi-contract. That means the court is saying, you don't have a contract, but we're going to we're going to enforce one on you anyway. I want to say make a fake contract. We're going to impose a quasi-contract. We're going to act like you did, even though you didn't. That happens to prevent one party from being unjustly enriched at the expense of another party. Here's an example of that. I'm sitting on my front porch and I see a paint crew pull up. They've got a van with their name, the paint crew on the side. It's a huge crew. They unload all the scaffolding. They put it up around my house. And over the course of 3 days, they give my house a brand new paint job. I didn't ask them to. We don't have a contract. There's never an agreement, right? That's where that would fail. But I did get my house painted. And I had the opportunity to correct the mistake and didn't do it. That's the key to quasi-contract. In that situation, the court might, not always. So this time, don't go around thinking, oh, well, I'm going to spend spring break painting people's houses and then I'm going to go sue them and get paid for it. It's not quite that easy. The key to it is that the person who is unjustly enriched had an opportunity to prevent it from happening and didn't. I should have asked the painting company, what are y'all doing here? I didn't hire y'all. Are you sure you're at the right place? Certainly over the course, they're going to paint my house for 3 days and I'm there. But what if I go on spring break and I come back and my house got painted? I'm like, I'm not paying for that. I didn't ask for it. We sure don't have a contract. There's never an agreement. They sue me under the theory of quasi-contract. Their case is not going to be as good because I wasn't there. I had no idea they were doing it. I never had an opportunity to object or to correct the mistake. So quasi-contract really comes into play when the person who's been unjustly enriched doesn't have clean hands in the whole situation. Like, yeah, I got unjustly enriched. and I knew it was happening. I let it happen anyway. That to a court might seem unfair. If you're my lawyer and I got my house painted and I was there, I had the opportunity to stop it and I didn't. Can you think of some other arguments you would make on my behalf? As to why I'm not unjustly enriched? I didn't benefit? What if the paint job was horrible? Hey, what if they painted it camouflage? What if it ruined or reduced the value of my home significantly? I don't know that a court is going to use quasi-contract to make me pay for something that devalued my home, or that I'm going to have to pay to get undone. So quasi-contract and promissory estoppel are not things that are very commonly used. The purpose of those two ideas is to just prevent somebody from being unjustly enriched or from incurring some detriment because they relied on something somebody else said they were going to do, even though they didn't have an obligation to do it. All right, so we got not off course a little bit, but we're talking through elements of a contract. We're talking about consideration, and I just gave you some examples of when a court might enforce an obligation even when there is no contract because consideration is lacking. Let's go to the element of capacity. So now I'm moving into part 2 of your contract law outline. So capacity, that's the ability of each party to a contract to understand what it is that they are obligating themselves to, what it is they're promising, understand what the subject matter of the contract is, understand what's going on. The courts are going to presume, they're going to assume that everybody who enters into a contract has the capacity to do it. Okay? That's the beginning baseline that a court uses. So if someone is using the defense of I didn't have capacity, they're going to have to prove that to the court. They're going to have to put up sufficient evidence that negates this presumption that everybody has capacity. We tend to think of capacity sometimes in terms of like mental capacity or being intoxicated or somehow impaired, and we're going to get to those. But capacity can also be decided by things like age. So if in most states, the age of majority for consent, to be able to consent to a contract is 18. All right. So anybody who's under 18 lacks capacity. Let's say that my 17-year-old daughter goes up to the car dealership and buys a car. She takes cash from my shoebox under my bed and goes and pays cash for a car, brings the car home. All right. I tell her, absolutely not. March right back up there, turn that car in, bring my cash back. She can do that because she did not have legal capacity to enter into the contract. But here's where this gets a little tricky. The only person that can use being underage to get out of a contract is the underage person. If the other party is of age, they can't use lack of capacity as a defense. So in my example, if my daughter showed up at the dealership that afternoon and said, my dad says I have to return this, I need my money back, and they say no, and she sues them, did they have an agreement? I'll pay you this much for the car? Yeah. Is there consideration? She paid money, they gave him a car. Yeah. Is there capacity? Not on her part. So they cannot force her to go through on a contract that she lacked capacity to enter into. But on the flip side, if they the next day decide they want that car back and they tell her to bring it back, they'll give her her money back, and she says no, and they sue her, they're out of luck. They can't use her lack of capacity for their benefit. Only the minor can do that. What happens when a minor turns 18? And there's an existing contract that they formed when they were a minor. The law in that situation says that the minor, upon turning 18, has to either disaffirm the contract, break it, get out of it, give back whatever it was they took, undo it. They have to objectively disaffirm it, or they can ratify it. They could say, okay, I know that I was a minor when I entered into this, but I would like to keep the contract going. I've turned 18 now. I want to keep it going. I want to be bound by it. All right. If a minor does that, they can't then turn around 2 years later and say, oh, by the way, I want to disaffirm this contract. I want to get out of the contract. Too late at that point. All right. So if my daughter turns 18 and she goes up there that day and turns the car in and demands her money back, she could do that. The law says that the disaffirmance has to be done in a reasonable amount of time. It doesn't give the law doesn't specify a set number of days or time period. It's a reasonable amount of time. If I'm her lawyer, I would say that on the day that she turned 18, that's a reasonable amount of time. If she turned it in the next day or the day after that, I would feel comfortable arguing to a court that that was in a reasonable amount of time. If she did it 2 years later, I would not have a good argument in court, because the car company, their argument would be, Judge, the law says she's got to do it in a reasonable amount of time. She waited 2 years. She made payments for 2 years. She kept the car for 2 years. That's not disaffirmance. That's an act of ratification. Where it gets a little murky is, what if she took it back 3 weeks after her birthday, 3 months after her birthday, 6 months after her birthday? Who's going to decide if she took it back, if she disaffirmed the contract within a reasonable amount of time? Who's going to decide if it was reasonable? Remember, if we have a dispute about that, we're in court. So it's up to the judge or the jury to decide if she did that within a reasonable amount of time. It would depend on the facts and circumstances of the case. Maybe she sent an email to the car dealership and said, I've just turned 18, but I'm putting you on notice that I affirm the contract. I intend to be bound by it. It's reasonable that they would rely on that. Maybe she stops making payments, and 6 months later, she gets sued. She turns the car in and says, I disaffirm that contract. The jury's going to have to decide whether or not the car dealership should have known that she was disaffirming the contract when she stopped paying. The longer she goes, the better argument for the car dealership. The shorter period of time, the better argument she has. Her actions matter too. If she's made payments for 4 months after she turns 18, she's going to have a tougher time getting out of it. This doesn't happen very often, but we just go through the mental exercise to kind of show you how the law would treat that kind of situation. All right, intoxicated persons. So again, if intoxication is asserted as a defense to breach of contract, in other words, plaintiff has sued defendant for breach of contract, the defendant's defense is we didn't have a contract. Even though we had an agreement, even though we both gave up consideration, the element of capacity is lacking. I was too intoxicated to understand, appreciate, know what I was agreeing to. It's on the defendant to prove that. What kind of evidence? Let's say you are my lawyer. I have entered into a contract and I don't perform, so I'm sued for breach. And our defense is that I was intoxicated to the point where it negates capacity. You're my lawyer. What kind of evidence is going to be? What evidence would you like to have? What kind of evidence? Oh, it'd be great if you had a blood alcohol test, right? Not likely, but that'd be awesome. Maybe if I was in an accident that night or I'd gotten pulled over and gotten a DUI and they'd give me a breathalyzer. That'd be good evidence, right? What else? Who can think of something else? Say it, Ian. Yeah, if somebody had videoed me stumbling, knee walking, passed out, intoxicated at the bar around the same time as this contract was supposed to have been agreed to, that'd be good evidence. Point being that the objective theory of contracts means that we're only going to use objective evidence to decide whether or not I was too intoxicated. It's not enough for me to go in and say I was blackout hammered. I don't remember any of this. That's subjective. And under the objective theory of contracts, it's up to me to provide enough evidence for a judge or a jury to believe that I lacked capacity. Hard to do. It would be great if I had a breathalyzer. It'd be awesome if I had a video of me stumbling. It would be great if I had a receipt from my bar tab that night that showed I ordered 50 shots. It'd be great if I had witnesses. But again, burden is on me to prove that I didn't have capacity. The case that you're going to read for week 2 involves an agreement that was made at a restaurant while 2 men were drinking for the sale of a farm that was written on a napkin or on the back of a menu ticket, order form. I can't think of the right name. Okay. One party tried to get out of it by saying I was joking, I was out of my mind, I was not serious, we were drinking and I was drunk and he should have known that nothing I was doing was serious. Who writes a real estate deal for the sale of a farm on the back of a restaurant ticket? They went to court and the court had to decide whether or not there was enough objective evidence to determine whether or not one of the parties lacked capacity because of intoxication. It's a really interesting case. And it's one that you can see both sides of. So we're going to talk a lot about that in week 2. That's how intoxication could negate the element of capacity. Mental incompetence. Let's get to that. Mental incompetence is also tricky to prove, right? Well, yes and no. If I've got a defendant who's being sued for breach of contract and the defense that we want to use is mental incompetence, if this person has a long history of mental illness or developmental disability that's documented, then that's easy evidence for me. Maybe my client can't read. It's documented that my client is 30 years old. They can't read because of their developmental disability. I can prove that. That'd be good evidence. What's harder to prove is temporary lack of mental capacity, like in the moment, or I was having a anxiety attack, or I was having a dissociative event. I got triggered, and all of a sudden I didn't know where I was. I was not even acting in my right mind. Harder to prove. Still a valid defense if you have the evidence for it. Just harder to prove. The best evidence, other than somebody having a long history of documented medical limitation, I guess I would say, would be as if a court had found that person to lack capacity in the past. That'd be great evidence. Here, this is a little bit off the track, but I want you to understand how this works. So in Georgia, if a person needs a guardian, and I'm not talking about the kind of guardian that you think of for like a minor, somebody who's under 18 whose parents die or doesn't have anybody to keep them. That's a different kind of guardian. An adult can be found to be in need of a guardian if they can prove, or if the person asserting that there's a need for a guardianship can prove that that person lacks the ability to make responsible, significant decisions for themselves. So think about like a developmentally disabled adult, or an elderly person with dementia. Those folks would lack capacity to understand what they're doing. And so if I'll make it a more concrete example. Let's say that my mother, who's 85, has dementia or has Alzheimer's, and she is entering into contracts with people who call her on the phone or on the internet. She's getting scammed, right? So I decide that she needs to have a guardian. In Georgia, I can go to probate court and ask that the court declare her incompetent and appoint her a guardian. If the court does do that, and it's an involved process, it involves her being evaluated by a neutral expert, doctor, psychiatrist, that kind of thing. And I'd have to go in court and use all this evidence and testimony, and I have to prove that she needs one. If the court does find that she does, then they will take away her ability to enter into a contract. They will legally remove that right from her, just like a person under 18. They don't have the right to enter into a contract. Same thing with a person who's been appointed a guardian. Now, this all assumes, in order for that to be a good defense in a breach of contract case, it assumes that the person had already been appointed a guardian before they entered into the contract. It's not a situation where mom enters into a contract and I'm like, let me go get her a guardian appointed so we can get out of this contract. It's not how it works. It just means that the evidence that I would use to show that she didn't have capacity is a court order finding that she lacks capacity. That'd be the best evidence I could have. So that's a little bit off of the path, but that's how lack of capacity works for mentally incompetent people. And when I say mentally incompetent, that's not just insanity. It could be, again, developmental disability, right? I just don't have the capacity to read or write or understand or reason. Autism could factor into that. All kind of different medical. So it's not just, yes, mental illness can negate capacity, but it's not just mental illness. It could be a medical reason that negates capacity as well. All right, let's talk about legality for a second, which is the fourth element of a valid contract. So I told you on Tuesday that Legality means that we can't have a contract if the subject matter of the contract is something that is against the law. Right? I was hiring a hitman to kill somebody in here. I think it was Hunziker. And was it you? I hired a hitman to kill you on Tuesday? Yeah. Okay, I thought it was you. And he does it, and I don't pay. And he sues me. I have a good defense. It was illegal, right? I can't be forced. Now, look, I'm going to get arrested because that's a crime. I violated the law. But I'm not going to be forced to pay him under the theory of breach of contract. Don't get me wrong. I'm not all free. A breach of contract is not available because this contract lacks the essential element of legality. Probably an easier example rather than murder for hire is, let's say that I run a sports book out of my dorm. I'm a student. Gambling is illegal in that form. That's a little bit murkier because gambling is legal in some states in various forms. But for me to run an unlicensed sports book out of my dorm room, that is still against the law. Ian places bets with me and he loses and he owes me $500. I sue him for breach of contract. His defense is, this is illegal. You can't sue me for that. The subject matter of our contract was something that is against the law. Another example of that is like usury laws. Those are laws that regulate or limit the amount of interest that can be charged in a contract. So say I go and pawn my car at the title pawn, and in exchange for them giving me some money, I give them the title to my car, and they're charging me 80% interest on the money they loan me. I don't know what the legal limit is in Georgia, but I do know that 80% is above that limit. All right, I can't make my payments. They take me to court and sue me for breach of contract. We did have an agreement. There was consideration. We both had capacity, but we're lacking the element of legality because the subject of the contract involved them doing something that is illegal, collecting an interest rate that's higher than the law allows. That'd be another example of where legality would be lacking. So it's not just certainly a contract to do something criminal lacks legality. But there could be something that's illegal that's not criminal. Does that make sense? Like charging an interest rate that's too high, that's illegal. It's not a crime. It could be a crime. It could be some of both. Sufficiently confused y'all enough for today. So we're going to stop there, and we're going to pick up Tuesday after spring break with another lecture class. I'm going to finish up lecturing on contract law, and then that Thursday of week 2, we'll discuss the cases and some examples. You have 2 cases to read for this unit, the Wright versus Newman case and the Lucy versus Zemer case. I don't need you to read them until that Thursday, but if you, for some reason, are bored on spring break and you want to read some case law, it's already posted. So nothing y'all need to do between now and Tuesday after spring break. I'll lecture again. You don't have anything due this week. Everybody have a great break. I will see y'all in a week. Hope y'all have good plans.